Okay, I think we've got most people on, so we're going to get started. My name is Karen Michaels. I am with Fidelity National Title. We are an underwriter for Consumers First, who is hosting today's presentation. And we're going to talk about foreclosure and REO today. I will send a copy of the attendee list and the presentation over to our folks over at Consumers First, and they can forward it on to all of you. So don't worry about taking a bunch of notes. This is probably, who knows what's going to happen next year. We do talk a little bit about predictions and stats. I'm actually getting on a call after this class to hear what the economic outlook is going to be for, the beginning of first quarter 2023. Nobody knows. I mean, we work in the housing market. It's up, it's down, loop-de-loos, all kinds of things, as we know. I mean, we thought COVID would be, nothing would be happening, and the housing market exploded. So we can expect a slowdown. But where are we going to be next year? This is actually a good class to help you prepare in case there is an uptick in foreclosure and REO, because you may deal with an REO property. You may have a buyer that wants to buy an REO property. So the first part, we're going to talk a little bit about foreclosure, go through the process, and then we'll review REO. And I'm going to throw in, this is what I did for the past like 15 years was foreclosure, REO, bankruptcy. So I'm very familiar with it. So I'll give you like tidbits and things, where if you wanted to get involved as a real estate agent, as a listing agent, I can give you some advice on that as well. All right, so let's get started. What is a foreclosure? It's the enforcement of a security interest, judgment, or lien by judicial sale of encumbered property. So here in Florida, we are a judicial foreclosure state, which means if you want to enforce a lien or your mortgage, you have to file a lawsuit and go that way. So that's all that means. There are obviously tax foreclosures. There's foreclosures when you don't pay your condo association dues. But today we are just going to focus on mortgage foreclosures. So let's talk a little bit about statistics. We had rising mortgage rates and falling home sales. Foreclosures are on the upswing, and we lead the nation in total foreclosures over the first half of 2022. We're sixth in the nation on a per home basis, and more than 17,000 Florida homes were in foreclosure so far this year. California at 16,000. Now, these are the actual statistics. If you are doing a search on foreclosures, and is it going to, if you pull up percentages and it's going to be like 300% more than last year. Well, last year we were still dealing with the pandemic. There were moratoriums on foreclosures through end of June 2021. So if you're comparing, August of 2021 versus August 2022, August 2022, you're going to have probably a 300% more increase in foreclosures. But it is still not a huge amount of them happening. But, they are thinking that we will see definitely more coming about as people, the economy, interest rates may be rising, tends to I think 2024 is going to be the election year. Things tend to quiet down because people want to see who gets elected, but 2023 might be a little volatile. So this, like I said, great information for you to have as we go into that. Just to give you an idea, Florida, number 6 in the nation, foreclosures per housing units, but we still have over 17,000 homes that went into foreclosure. Florida's always going to be in the top 10, period. These are per housing units. If we did actual numbers, you would always see Florida, California, Texas, New York, Michigan, Ohio. Those are always in the top 10. And then one of their other Rust Belts Rust Belt states will pop in. And it's just the way it is. It's, obviously in Michigan, Ohio, you've got automotive industries and other industries, and then just population in the other states. So we'll probably see this increasing here in Florida, but it's not what it was back in 2008, and they don't predict that it will be. So ATTOM, they do all this market research on the economy, especially housing. And so they come out with some information. They said foreclosures will likely continue for the rest of 2022, an increase, I should say. And then they still expect them to stay below historic levels at least through the end of the year. So what I've seen, and this was before this economic thing, I'm going to do it too. We're being told that you're going to see a wave, definitely a wave of foreclosures, but not the tsunami that was 2008. There's a lot more regulations on lenders than there were prior to 2008 that caused a lot of predatory lending, that caused a lot of foreclosures. People have equity in their homes, which they didn't back in 2008. So there's quite a few things where they don't predict that explosion. But we're still going to see some. And if anything, I personally think here in Florida, you're going to see a lot of condo foreclosures, especially since we have that new condo law that came out July 1st regarding, you have to have certain reserves if there are structural integrity issues. And so that might cause people to say, I'm getting out of this. It's not worth it. Here in Southwest Florida, my mom actually has a condo on Fort Myers Beach, and thankfully for her, they passed the structural integrity after the hurricane. There's still obviously a bunch of cleanup, but there's places down there that are just not going to be recovered. So I have a feeling you're going to see foreclosures pop up with condos a lot, especially older condos. So, like I said, great time to get in on this class and learn what this is all about. All right, so let's go through a foreclosure process. And I always start with, and this was something, I'll give you some more stories, but this was something that I was amazed with when I first got into foreclosure, that people, and this was also back when there was predatory lending and people were refining every 15 minutes and just stripping equity out of their home and not really know what they're signing. But we would do a foreclosure and the borrower would be dumbfounded that they had to pay that money back. When you do a closing, you borrow money, you sign a note, a promissory note, and you sign a mortgage. The promissory note is just like it sounds. Lender is giving me money. I promise to pay that back. And I'm going to sign this document, this contract that agrees to that. The mortgage is the security for the debt, and that's what we put on record. That's what we record, that puts everyone on notice that we have borrowed money from a lender and they have a security interest in our property. So those are the two documents. And of course, nobody reads any of this, right? Nobody reads any of the closing documents. Last closing I was in, it was like sign. I'm like, okay, excellent. You don't know what you're doing. Biggest purchase of your life, but that's fine. But I just want to stress that. Like I said, amazed that people did not know when they got a loan out that they had to pay it back. So the promissory note, that's all it means. Promise to repay the debt. And the mortgage is that security that puts everyone on notice there's a loan. And that the lender has the ability to foreclose then if the debt's not repaid. You have, with most lenders, till the 15th of the month to make your payment. So if it's due on the 1st, they give you a grace period, 10 to 15 days. 15 is pretty much average. If you don't pay your mortgage on the 15th, on the 16th, you are technically in default on your loan. That's in the mortgage documents. Clearly states, it's actually on the closing disclosure as well. But because there were so many foreclosures between like 2008 and 2012 in particular, the Consumer Financial Protection Bureau, the CFPB, kind of stepped in and like, this is out of control and we need to protect consumers and their interests. So now the mortgage servicer must wait until the mortgager is 120 days delinquent on their payments before starting the foreclosure proceedings. Previously, the 16th of the month the foreclosing attorney that the bank has hired would be sending out a notice of default to the borrower. Now we have to wait and see if there's anything called loss mitigation efforts, like a loan modification, maybe a mortgage forbearance, something that puts a Band-Aid on it until the consumer, the borrower, can get back on their feet, can start making their payments regularly. So we do have a waiting period. If there aren't any loss mitigation efforts available, then the bank sends a notice of default, and that goes to the borrower, and it says, hey, you haven't made a payment, you have a date to cure, and if you don't, we're going to start foreclosure proceedings. So Florida, like I said, judicial foreclosure. Some states, you don't go to court. Some states, it's foreclosure by advertisement, where the foreclosing attorney for the bank would just advertise in a local paper that there was, the property is in default and that there's going to be a sale. That's all that you need to do. Here in Florida, the bank has to sue the borrower. So with that, the bank, the lender, files a complaint. The complaint is served on the borrower, which is the defendant. And if the borrower does nothing and doesn't respond to that complaint within 20 days, the bank will go back to the court and say, borrower didn't respond. And the court grants a default judgment in favor of the lender, which means they can go to foreclosure sale without any word from the borrower. If the borrower responds, the lender typically goes back into court and files a motion for summary judgment, because all they have to show is the borrower didn't pay their mortgage, and here's the note that said they would repay it. And most courts are like, yep, that's fine. Or sometimes it does go to a jury trial. Why? Because there was some sort of default or some sort of error in the process. Either the mortgage didn't have proper parties signed, didn't proper legal, all kinds of things that could cause which means the mortgage could potentially have been voidable. So most of the time it's a default judgment, because some people just don't even respond. They're like, yeah, I didn't pay my mortgage, I don't care, just go to foreclosure. But sometimes we do see a jury trial. And actually, back in the day, in the height of foreclosures, we had situations where there was an issue with like the mortgage, and that case had been tied up in the courts for 3-4 years as a foreclosure proceeding, which means, the bank wasn't getting their money from the borrower, and the borrower wasn't paying it because they were like, yeah, we're still living here, we're not making payments, for 4 years. Now, once again, we've kind of cleaned that up too. It was really ugly back in 2008 and through 2012, but that's the general idea. So you have to go to court. Who files the foreclosure action? It's going to be the plaintiff is the note holder. So in mortgage banking, and this just happened to me last week, I got a notice that my mortgage was being service transferred to another lender. And that happens all the time. And with that, there's an assignment of mortgage that gets recorded, and the note that I signed at closing now goes to the new holder of that, or the new lender. That lender can now file foreclosure action if I don't make my payments. My previous lender cannot, because they are no longer the note holder. The defendant is going to be pretty much anyone that has an interest in the property. So the owner, the borrower, the spouses. You have to let the spouses know in a homestead property, because they have an interest in it under the homestead constitutional provisions. But if they're not in title or not, any tenants to the property, you have renters, they have to be informed, and any subordinate interests or junior lien holders. So just to let you know how it is here in Florida with recording, and this is what we try to do in the title world. So Consumers First, when they do a closing and we have a loan and a purchase money mortgage, we are paying off everything that the seller owes, any mortgage they have, all those liens. because here in Florida, it's a first in time, first in right recording state. So whoever makes it to the county first wins in term of priority status. So we want to make sure our lender that is giving the money so the buyer can buy the property is in first lien position. So that's what we do in title. We clear off all the old stuff. So our lender can be in first lien position. And then anything that's recorded after it is a junior lien holder. And all of those people, because they still have an interest in the property, even though they're subordinate to us, have to be included in the complaint. So they all have to be put on notice that there is a foreclosure action and that they may be losing their interest. Interests that can't be foreclosed are superior lien interests. So if we have a mortgage that's recorded before our mortgage that wasn't paid off and released, that can't be wiped out. So you rarely see like a junior lien interest or a second mortgage foreclose for down payment because they're subject to that first mortgage. So when we are doing a foreclosure, or when a foreclosing attorney gets a file, they do a search to make sure that that mortgage that is trying to foreclose is in first lien position. If not, the old mortgage has to be resolved. Otherwise, really, there's no point in foreclosing. How do we know there's a foreclosure? So when Consumers First gets a file, they do a public records search. They look at everything that's recorded against the property, lien position, et cetera. And they look for things called lis pendens. And lis pendens just means litigation pending. And that's what gets recorded at the county level that puts everyone on notice that there is a foreclosure action. Lis pendens also get filed for construction liens and for condo association foreclosures. But for our purposes, we're going to look at lis pendens as for the foreclosure. So when that lis pendens gets recorded, determines who basically gets wiped out in the foreclosure, who has to be included in the complaint, because it kind of puts a stop to what's going on. So anything recorded before the lis pendens has to be a party to the foreclosure action, has to be given notice in a complaint and let them know, listen, this is part of the foreclosure action. They have the right to potentially redeem the property if they have an interest. If it's recorded after and that lis pendens, it's technically wiped out. You're out of luck because you should have searched the records, sees there's a lis pendens that now, you kind of lost your interest. The only things that don't get wiped out are typically, first of all, taxes never get wiped out. You owe property taxes. Property taxes actually have super priority status over everything. So we could have a tax foreclosure and a mortgage foreclosure at the same time. If the tax foreclosure wraps up sooner, they're going to get the property taxes, or this assessor gets the property tax or the property. I cannot talk today. So just know that you don't wipe out taxes. You still have to pay your property taxes, or lenders do. But municipal liens and county liens typically don't get wiped out. Most of them have some sort of, not super priority status, but they have a higher priority status than any recorded lien. So they don't get wiped out. Plus, we've got this thing called a cross attachment. So a lien on one particular property, municipal and county lien, that is, cross attaches to all of the other properties owned by the violator in the county where the lien is recorded. Code enforcement lien becomes a lien as priority is determined when it's recorded in the official record. They do not have super priority status, but they do have a priority status. So, for example, let's say I have 3 properties. Let's say I have 2 properties. It makes it easy. I'm in Orange County, so I have one in Winter Park and one in Orlando. My Orlando property is being foreclosed and there's a code enforcement violation. Orange County's like, yeah, whatever, we don't care. We're going to attach that to your Winter Park. It's not going to get wiped out. It's going to still attach. And that's what they do with a lot of the county and municipal liens. So that's one way that the city and county protect themselves. Also, Yeah, like I said, property taxes, doesn't matter. They attach, they super or precede everything. Condo association liens, any HOA lien. HOA liens typically, well, the rule is there's a Florida statute that says, let's say you have a condo association lien. This is why we ask for estoppel letters, because if we don't ask for a estoppel letter, and we don't know what's due and owing, our buyer's on the hook for everything that's due and owing for as long as there's something due and owing prior to them buying it. So we get estoppel letters that show us, oh, seller owes this amount, and we pay that off at closing, so our buyer gets the property free and clear. And then they're responsible for their assessments afterwards. If this, so the Florida statute as it relates to mortgage foreclosures is the bank is not going to be responsible for everything that's due and owing that the seller didn't pay on their association dues. They're only responsible for the past 12 months before they receive the property in foreclosure, or 1% of the original mortgage debt, and that's it. Condos cannot go back and try and collect since the beginning of time, because really that lien for the condo association goes back to the declaration of condominium. So when that condo was established, but not for mortgages. You don't really have to worry about that. That's something on the title line that we fight with condo associations with, and we have to pull out the statute and be like, no, we're not paying for everything. We only pay for 12 months. And that's a little caveat. All right, so after trial, the court issues a final judgment. Must be recorded in the county where the foreclosure property is located. It's going to contain all of this information. The amount due, date, time of sale, etc. So the final judgment is what gets recorded, puts all of us on notice that this case is done. And now our next step is a foreclosure sale. Notice of sale. And I put some of this stuff in here and you're probably whatever, but this is important because if one of these things is missed, we don't have all the right people on the complaint, we miss a party, or we don't have the proper notice. Instead of, let's say we had notice 40 days after judgment. Well, guess what? We have a problem now. Maybe we have to re-foreclose, maybe we have to repub, we have to do a bunch of different things. So notice is very important. And the court is the one that has to provide that notice. So then notice of sale must be published once a week for 2 consecutive weeks. Last one, not at least 5 days before the sale. So at the foreclosure sale, property is sold to the highest third-party bidder who is not related to the borrower by any shape or form. So it can't be your brother that goes in and buys the property. It has to be a third party that has no connection with the borrower. Otherwise, it's considered fraud. And then if not, then it reverts to the foreclosing lender. I'm sorry, my pool guy just showed up and the dogs are losing their minds. Excuse me for that. I'm like watching them try to kill them. Okay, that's probably not good. So the highest third-party bidder, if no one bids, foreclosing lender gets the property in REO. REO stands for real estate owned. The foreclosing lender is the one that starts the bidding. So if no one bids higher than that, then it goes back to them. So that's where we get REO. Once the sale of after the sale of the property, clerk files a certificate of sale and serves a copy on each party. Certificate of sale is going to show all this information, but in particular the highest bidder and the price. From there, the borrower has 10 days from the sale to dispute the bid. Most people don't. After 10 days are up, then the clerk is going to confirm that sale if there's no dispute, and they file or issue a certificate of title, which gets recorded, which is the deed. Like we call a certificate of title for cars when we transfer our car, certificate of title for foreclosure property that's transferred to whoever the bidder was. There is a right of redemption that the borrower does have, or even a junior lien holder has, and it will be in the final judgment, or if it's done before the filing of a certificate of sale. And all it is it shows you the amount of money that's due and owing, and it's going to be everything: attorney's fees. You're going to have to pay off the entire mortgage. It's not just, oh, I missed a month, I'm going to pay that month. You're paying off the entire mortgage at this point, and you get your property back. Talked about a little earlier, if we leave off a junior lien holder, we have to go through the whole process again and re-foreclose the entire file. And that does happen. I mean, we've gotten to like under contract with the buyer, and all of a sudden there was a junior lien holder that maybe was not properly recorded or just completely missed. It wasn't indexed properly at the county, and we've had to re-foreclose. And we're just like, that's going to take a couple months. Okay, that's the foreclosure process. And you might be saying, well, where do I come in as a real estate agent? Not typically in the foreclosure process. You do come in after foreclosure, not to evict people, but to do this thing, cash for keys. So once foreclosure is over and you have tenants, or the homeowners, not tenants, the borrower and their family or whoever living in the property, they have to be removed. So that's the eviction process. But what a lot of banks wanted to do and started doing during the foreclosure crisis last time was they were like, we don't want to kick people out of their homes and go through an eviction process. And it's just bad press for us. We already have enough bad press. So let's do this thing called cash for keys. So what it is, and this is where they hire you as a real estate agent, you go to the property and you have a check. And you say to the homeowner, you give me the keys, I will give you this check. And it can be anywhere from like $500 to like $3,000 or more. That comes from the bank. We can avoid the eviction process. You move out, you get this check, which cannot be moved, whatever, and we're good to go, and there's no eviction. And some people agree to it. Some people are like, get off my yard. But this is where they hire a real estate agent, because they're not going to send a bank representative. They want to hire someone that's good at marketing and sales. So they hire you guys, and you go to the door and, try and convince them that this is a much better option than eviction. If they're like, nope, you have to evict us, then we go through a regular eviction process as you would with landlord, tenant, whatever. So as part of the foreclosure action, it's going to be, there's a right of possession in the final judgment. So the lender has the ability, or the third party bidder has the ability to remove the homeowner, but it has to go through the court. So certificate of title is issued, the lender files a motion for writ of possession, court issues the writ gives homeowner 24 hours to move out. So once that motion is granted for the writ of possession, sheriff goes to the homeowner, here you go, you have 24 hours, and then we're coming back. And if you are not out by 24 hours, we change the locks and we move all your stuff and you out onto the curb. And that's an eviction process. And they have the right to do that under the law. So that's why we kind of push for like cash for keys, because this can be a very awful experience, the eviction process. What happens if you have tenants that were paying rent? Well, we're protecting tenants in Foreclosure Act. This is a federal rule that came about during the foreclosure crisis because people were like, oh no, well, I'm a tenant. We're like, okay, well, prove it. So under the PTFA, as long as there's a bona fide lease, which means that lease has to be between two people that aren't related, has to be for fair market value, and it has to be in writing, then if they can prove it's a bona fide lease, you can't say, my mom lives with me, she pays me $50 a month. That's a related person, and that's not fair market value. So those people would be evicted with you. If you have a valid lease, you have protecting tenants in foreclosure, and that gives the lender then has 90 days to provide the eviction, or a lot of lenders now just let the tenant write out the lease. Why? Because they're getting payments each month, and that's better than having an empty place. So if the bank gets a property back, it's called an REO, real estate owned. Let's talk about the REO process. This is obviously where you, as a real estate agent, are going to get involved. If you were a listing agent for an REO bank, you need to understand all these rules. If you, more importantly, have a buyer that wants to buy an REO, it's not anything like buying from a consumer seller. This is a business to consumer transaction, and it's very different. And people get very upset because it's not, well, this is, why can't I argue this and negotiate this? And it doesn't work that way with the banks. So REO banks, very methodical in their process, very hard to deviate from the rules. Doesn't mean that they won't do something to make the house more appealing, but for the most part, they don't. This is this asset has cost them a lot of money. They've gone through a foreclosure process that's cost money. The holding costs for having a home on their books every day is expensive. They want this thing gone. It's an asset. It is not a house. It's actually not a home. It's an asset to them. So that's how you have to think about it, whatever side you're on. They have an REO addendum. It's a multi-page addendum. They use the as-is contract, but this addendum is going to change everything in the contract. Timelines. There is no 15-day inspection. They want to get this thing off their books. They disclaim any liability for anything that could possibly be wrong with the property. They've never lived in the property. They don't know anything about it. So they are saying, we don't know anything about it. There you go. Now, of course, they have a duty to disclose anything that they know that materially affects the value of the real property that's not readily observable to the buyer. That's in 10J, but they are restricting their liability to only the amount of time they've had the property in their possession through the REO process, and that, you know what, we don't know what we don't know. So you really buy as is when you buy an REO property. With that addendum, there's, like I said, a bunch of changes. They also are very strict as to the timeframes. And this is where, if you were a listing agent for an REO bank, you have to adhere to these timelines, or you are not going to get any more business from them. If it's a lender deal where the buyer is getting a loan, 30 days maximum. It goes 31 days. That's like one less file you're getting next month. If it's cash, it's like 10, 15 days. They want things closed. If the buyer delays the closing, they have to pay a per diem charge as a penalty. So it can be $50 plus. So I'll give you an example. We had a buyer it was a Friday afternoon before a holiday weekend, as all good closings and issues come up. They were buying an REO bank property. Addendum was $250 per diem if we didn't close. The buyer's lender wanted to make a change, and everything has to be approved by the REO bank. So in a normal transaction where there's buyer has a lender, the lender wants to approve everything. Well, the REO bank overrides all of that. They're like, these are the rules. This is the addendum the buyer signed, etc. So with that, the buyer's lender needed to make this change. We had to send over the settlement statement to the REO bank for approval. They're like, no, we are not approving this change. Change it back or we're not closing. So we didn't close that day. And because the buyer's lender, they refused to make the change back, we ended up working it all out and ending up closing Tuesday. So it was a Friday afternoon to Tuesday. But the REO bank's like, well, you have a $250 per diem because you didn't close. Doesn't matter if it was the lender delay, buyer's delay, whatever. It's all on the buyer. So $1,000 the borrower had to pay the REO bank because that buyer's lender wanted to make a change. So that's how kind of strict and crazy it is. And it's all laid out in the addendum. Oops. Negotiations, they rarely negotiate. They don't want to. They're moving this asset. They want to get this off their books. So you buy as is. Now, Fannie Mae, Freddie Mac, any of the GSEs, they have to do certain minimum repairs to a property. That's because it's a government-backed mortgage. So they have certain requirements. But when I was doing foreclosures, I mean, we'd go on property tours with the banks. I mean, I saw things that were just unbelievable. And that's how they were selling the house, not making any repairs. They're not going to negotiate anything. So if you're the buyer's agent, you want to make sure your buyer has a really good inspector so that your buyer is going in with eyes wide open as to what the issues are with the property and really weighing, is this a good investment? Because their banks aren't going to negotiate. I mean, another example, Fannie Mae was one of my clients, and I had an employee that found a Fannie Mae REO, and she wanted to buy it. And we're like, okay. So I called Fannie Mae. I'm like, so-and-so who works for me is interested in buying this property. They're like, yeah, put her under contract. So that happened. And then like every other day, she had another thing she wanted fixed and blah, blah, blah. And Fannie Mae's like, we're out. We're not fixing anything. You signed this addendum. It's all laid out in there. And she lost the deal and she's very upset. And I'm like, you can't go back and like nitpick stuff. You agree to a contract. Your inspection period allows you to walk away. And that's kind of how it is. So keep all that in mind too. Banks also hire these things called asset managers. That's all they do is manage the asset. So a lot of these, no one's in Florida for the most part. They're all like in Texas. Everyone's in Texas, the banks, the asset managers. So a lot of people don't know Florida law. And that's something you have to keep in mind too when we're looking at negotiations. Well, there might be something that allows for a better negotiation because of Florida law. Repairs, like I said, they don't do any repairs. I have seen situations where, also just back to the whole, how do they figure out what they're listing the property for? It's all like AVMs. They do a bunch of comps and all of this, and they figure out from their bean counters behind the scene at the lender what they can sell this property for that makes them, not bleeding money, essentially. It makes their investor happy because the investor is the one that's going to get paid off when this deal is done. And there may be some leeway for some repairs, especially if it's something like a caved in roof, or even though that might be an as is. But I have seen them like give a credit for a repair here, but really rare. And once again, if you keep going back and like, well, this needs to be repaired and this needs to be repaired, they're like, hey, have you read an as is contract? Do you want to buy it as is? You don't, then you're not buying it. Cash is king, obviously, when you're buying an REO. Why? Because they can close them in 10 to 15 days as opposed to waiting 30 and then dealing with the buyer's lender. If the buyer is getting a loan, they foreclosing bank, the bank that now owns an REO, will more than likely want a pre-approval letter from the REO bank. So Wells Fargo does this. Wells Fargo owns the property as an REO. And you have a buyer that is now, submitted an offer. They want to get a loan. Wells Fargo say, okay, you have to be pre-approved by Wells Fargo. You do not have to close with Wells Fargo as your lender, but they want that assurance that you can get a mortgage, and they want it to go through their process. The larger the escrow deposit, the more serious buyer. Just a note too on cash, because I have this on here, I jumped over it. The banks take lower offer in cash to move the asset, absolutely, because they can close 10 to 15 days. So I've seen, let's say a property was listed at $300,000, there's a $310,000 loan offer, a 280,000 cash offer. Bank might take that 280,000 cash offer because they can get this off their books. And when they're figuring out the valuation of the property, they do have like sort of that pocket, the low end, the high end. Earnest money deposit, the larger escrow deposit, the more serious buyer. Choosing a title company, the banks have vetted their real estate agents, and we'll talk about that in a minute, and their title companies and their foreclosing attorneys. So they want to use the people that they've chosen. So the RESPA Rule 9, seller can't force the buyer to use the title company the seller wants and then require the buyer to pay for their own owner's policy. It does say, you know, seller, it's in the FARBAR contracts, seller picks title company, seller pays for the owner's policy. So banks will use as an incentive because they want the transaction to go through their vetted title company who knows the REO rules and understands the addendum and is adhering to the timelines, and they can get this thing closed. If you have a split transaction where the buyer picks their own title company, the REO bank's still going to use their title company. But now we've got a real headache because typically if the buyer is choosing a title company by themselves, they might not know anything about REO and they don't understand the timelines and all the stuff that's involved. Bank's not going to be present as closing. Who was ever present at closing? Buyer may not actually get the keys the day of closing. That is something that happens with REO properties. Why? There could be a myriad of reasons. I've done closings on, once again, Friday before a holiday weekend. Buyers got their U-Haul all packed up with their belongings. And I'm like, what do you, and we used to have to send out notices like, do not expect the keys the day of closing. Because we've had the situation where someone's ready to move in. We're like, no, there's an issue with your lender or whatever, and we can't close today, and we're not giving you the keys. And everything has to be approved by the bank, like I said. Any change on the buyer side has to be approved by the bank. They are running this transaction. So now that I made it sound like such a great experience, how do you become an REO agent? There's REOMAC and 5-Star. They're the two biggest organizations, probably. There's MBA Default Services, but that's really geared towards foreclosing attorneys. But these two groups are comprised of real estate agents that do REO, servicers that service REO, asset managers, title companies that do REO, foreclosing attorneys. It's everyone, runs the gamut. So if you were interested into, I want to know more about this, I'd say get on the REOMAC website, find out who the players are, maybe in the area, see if you can talk to them and see what they think about it, or just see who is potentially offering business. 5-Star, they both have annual conferences. They have meetings constantly. There's a bunch of information on their websites, but you can see who maybe the servicers are that are out there, the asset management companies that are out there, and that way you can reach out to them and see if you can get on their roster for getting business. Platforms, Equator, ResNet, working with asset management companies. There used to be, when there's a lot of foreclosures happening, like 50 asset management companies. There's not a lot anymore because there's just not a lot of REO. So the big ones are Green River Capital and Vendor Resource Management, VRM. And all you do is like go on their site. Best thing really though is, especially with REO and foreclosure, it's networking. You have to go to these networking events and you have to get to know people. But Fannie Mae does an open enrollment once or twice a year. I don't know when it is, but you can go on their website and find out and see if you can get on their roster. You have to fill out an RFP, and that is going to be a bunch of questions on your experience, references, cybersecurity, all kinds of things, because they're vetting you. Because at the end of the day, if you get their business, you kind of are representing the bank. There's servicers or sub-servicers. Servicers, obviously, they service the loan, the REO. Sub-servicers are the ones that they're just buy them for pennies on the dollar, and then they try and get rid of them in REO. This is why they change a lot all the time on what they're doing. That's why I'm always like, just go to REO Mac or 5-star and see who's doing what. And with that, that's all the information I have. Is there any questions? I think I just say the chat box is good if you want to ask anything. I will send this over, like I said, with the attendee list, so you can have this information. Just pay attention to what's going on. Like, there is economic updates happening regularly as we get into 2023. Great idea to get on some of those and just see what people are saying. You know, it's who knows? Like I said, they don't predict that it's going to be what it was, but the potential is there that we are going to see an uptick and we are going to have REOs. And I say be on the lookout for condos that are in REO. Excellent. Well, thank you, Consumers First, for letting me do this today. I think we have another one coming up soon. And if not, have a great rest of your day. Thank you.